Welcome to the It's Been Said podcast. I'm your host, SAI Executive Director Lisa Ramey. Today's episode is a special edition of the It's Been Said podcast. Matt Carver, Legal Services Director, will discuss his perspective on current legal topics relevant to district and school administrators. He'll offer his insights on this subject matter periodically over the coming months. Let's hear from Matt.
This is Matt Carver, and this is SAI's Legal Vortex. So, welcome all those listening. This is our first episode of Legal Vortex as a podcast. And as you might have read already, we're having a little different format with how we're putting out some of the legal information. So some months you'll be receiving a column from me that's sent out by SAI. And during other months, it will be in the podcast format. We'd love to get any feedback you have relating to getting this in the podcast, as well as the written format. Just let us know. We're always open to suggestions that you might have and look forward to further interacting with our members. So, for this episode, I'm going to talk about something that's been in the news a great deal lately and that has been weighing on a lot of our members. It's a very difficult topic to cover. It's been very emotional in our communities. And so I'm going to talk specifically about employee speech. And with the recent political assassination that we've had here in our country of Charlie Kirk, there's been a lot of media attention relating, of course, to that event, but also a lot of attention on comments that some public employees have made, not only school employees, but other public employees throughout our country. And I'd just like to start out with the bottom line up front on this. And the bottom line up front is, if you have public employees, school district employees, whether they have a Chapter 279 contract as a teacher or as an administrator, if those employees are publicly celebrating the political assassination of an individual, that is just cause for termination. So I often over the years, and I've been doing this for almost 20 years now, as some of you know, often over the years, I'll get calls. And when I get calls about issues of speech or other topics, and the language I'll often use is, well, yeah, that's sort of a slam dunk. You're in a very strong position to terminate an individual. But I often stop short of making a recommendation. I'll say, well, you have the authority there. You're in a very strong position. I don't see this being overturned by the courts. On this topic, I do make the recommendation that you send those individuals to your board for termination. There's just no place in our schools for individuals who celebrate violence against others, regardless of those beliefs. In a political matter. There's just no room for it. So I just wanted to start off with that up front. So we're very clear about that, about my positions on that, and as well as the strength of the district's position. So send it to the board. It's ultimately going to be their decision to make anyway, and allow them to make that decision. Another thing that you might consider, and I wouldn't be surprised if we see more on this. I know we've had some communications already from the DE, is while this is not a required report to the BOE, it's certainly appropriate to report such types of public communication celebrating violence to the BOE as well. I mean, it's clearly unprofessional, and it's something that certainly would justify such a report. Okay, now that I've gotten that difficult topic out of the way and sort of the big issue of our day here recently, I just want to go through the framework and just to go through the overall. So we'll step back here for a second and I'll go through the steps that even, coming up in future months, future years, as you're trying to determine what to do when you have an employee that's made certain speech, what are the considerations that you should make? And the first consideration I'd encourage you to make is decide, well, was the employee speaking in their official capacities or were they speaking as a private citizen? So that would be the first step. So think about such things as, all right, was this something that was done in front of the class? They're doing it in front of the class. Or it's some other school employee and they're at a school event of some sort, a school activity, and they're doing that in their official capacity. Now, if it's outside of school, it's outside of those activities, you might also consider, are they on social media, but they're saying, hey, this is Matt Carver, and I'm an administrator, I'm a teacher at this district, and they're sort of using that position to proclaim something. And if they're doing that, then I think a pretty strong argument can be made that that's also being made in their official capacity, albeit outside of work hours. So with this, if the duty is in their official capacity, then we follow some guidance that we've had from the United States Supreme Court in the Garcetti case. And in the case, the court stated pretty clearly that employees, if making speech in their official capacity, they're speaking on behalf of their employer and do not have First Amendment protections. Okay, so they just don't have those protections there. Now, I'm going to get to some things later. This doesn't mean that while someone's working that they have no ability to express their beliefs in a number of different areas. But if they're speaking on behalf of the employer, then that's speech of the school district, that's speech of the university, that speech of fill in the blank, whoever the public employer is. And so they don't have those same First Amendment protections there. So that's one. Consider if it's in their official capacity. If so, we're going to follow the Garcetti case. Now, beyond official speech, and this is where it gets pretty tricky, and this is where we've seen some of this, albeit I think here recently it's been a little easier to make these decisions because it's so clear how it crosses the line. But if it's in their personal capacity, their private capacity, they're outside of work time, they're maybe on social media, they're out and they get interviewed someplace, well, then we're going to follow the Pickering case. And in the Pickering case, and this is another Supreme Court case, the Supreme Court laid out a couple of different things, and the balancing test is put into play here. But first, we're going to consider, is this a matter of public concern? So whatever that topic is it a matter of public concern? Now, you might ask, well, what would be a matter of public concern? Well, some things that might be a matter of public concern in the specific example in the Pickering case where the employee's speech was upheld related to a bond referendum. So that's going to pretty clearly be a matter of public concern in their private capacity. You could have a school employee, for instance, that if they're doing it in their personal capacity, their private capacity, they could say, hey, I recommend against a bond referendum, even if it's from their district. Now, hopefully we don't have too many who are doing that, but they could, and they have the right and the ability to do that. So that would be protected speech. Many other areas where it's going to be considered a matter of public concern are going to be policy issues. So think about some different policies that we have in our country, in our communities, whether they be local or municipal policies, state policies, federal policies, that many of those, or probably all of those, are going to be matters of public concern that those employees could, speak their views on that. However, I probably should be a little careful how I word that, is that the balancing test also includes an analysis of, does that speech create inefficiency in the workplace? So that's the other piece of it. So first we consider, is it a matter of public concern? And then, even if it is a matter of public concern, is that speech creating inefficiency in the workplace? And so that's another thing that you're going to need to consider in determining whether or not their First Amendment or the extent really of those First Amendment protections, those individuals when they're making comments in their private or personal capacity. So, what might be examples of creating inefficiency in the workplace? It might be you have an employee. So now we're talking about schools, of course. You have an employee, and that employee's a teacher, they're a coach, again, they could be an administrator, and you have parents coming forward, probably numerous parents, multiple parents saying, hey, I don't want my child in their classroom. I don't want my child on their team. I don't want my child in their building because of this. You're getting swamped. The principal's getting swamped. The superintendent's getting swamped by emails from community members that are concerned about this. You're having to spend a great deal of time responding to these emails or reading these emails and going over this and dealing with this issue that was created by the speech of that employee. Now, as we get into that, and if it is a matter of public concern, and there's some question about inefficiency, then at that point, if you're going to take further action, I'd certainly encourage you at that point to get your district's legal counsel involved. I've certainly gotten many calls over the years of this. As you know, I represent our members, and so I can give advice to administrators, but I don't advise the school board. So if it's something where the school board is likely to get involved at some point, I'd certainly encourage you to get your district legal counsel involved as well in helping you to make that determination of, okay, well, what's the best action here? Now, often my experience has been if it's something that is creating some inefficiency, in many instances, it's just a matter of talking to that employee and saying, hey, we're having issues with this. Often I've seen where employees on their own have just decided to just take the post down, even if it's merit, they might just decide, you know what, it's not worth it. Yeah, I see this is causing this. That's not my intent. I feel strongly about it, but I don't want it to interfere with me educating my kids here in my classroom. I don't want it to interfere with my ability to coach the kids that I coach and I care so much about on my athletic team or in the band or the choir or whatever the case might be. And that often happens where those practical steps are taken. Sometimes they're taken by the employee before our administrators even hear about it. And I've received numerous calls where employees have come to building principals, and then I've later gotten the call, and they've sort of said, "Hey, I put something out there, got this strong reaction, I took it down, and I just want you to be aware of it." And I think all those things, the actions of the employee there in deciding to take that down. I think all those things are things that are considerations that might mitigate what other action the district may take. Now, I say this, and we do want to be very careful because I'm certainly not suggesting that public employees have no ability to speak. They absolutely do have ability to speak, but they also have to realize that their rights to speech are somewhat limited if they want to continue to have their job with the school district or with that public employer. So individuals in our country have many rights and abilities to speak, but it doesn't mean your ability or right to speak does not mean necessarily that they have a right to a job. And so they need to remember that as well. It's not that you're telling them, hey, you can't say this. They might feel so strongly about it. They might say, hey, even if this means I might lose my job, I feel so strongly about this, I'm going to leave this out there. And that's their choice. And that's one of the great things about our country is they do have that choice, but sometimes our actions have consequences, and they just need to be aware of that as well. So again, look at, is it official speech? Is it personal or private speech? Again, often that personal private is going to be outside of school. It's going to be on their own technology. It's going to be on their own personal social media page. It's not on their social media page that your school district might have set up for them for their classroom, for an example, or that a building principal might have to send things out to all the families of students in the building. But rather, it's again their personal social media. Look at that, go through that balancing test with Pickering. If you have questions, of course, call me on that as well. But those are the first couple of things you want to consider. Now, another area that's come up recently is, well, where does religious expression then fit in? And you might recall a few years ago we had the Kennedy case concerned a coach in Colorado, and the Supreme Court upheld the ability of that coach and really gave a lot of clarity to questions that we've had over the years with religious expression for our school employees. And so, what the Supreme Court stated there was that there are some additional protections, not only your right to speech, but some additional protections for public employees when it relates to religious expression. So there, the court largely focused on, okay, is this religious expression? Is this something that's happening sort of openly when they're actively instructing students, whether as a teacher or as a coach, or again, go back to thinking of carrying something out in their official capacity, or is it happening at some other time? So, for instance, in that particular case in Kennedy, they considered the game was over. The coach decided to pray, but this was at a time when the coach did not have duties to supervise the students. He had other coaches that were meeting with their families after the game, talking to families, they were talking to parents. It was sort of a little bit of a free time after the game, and that was something that the court considered there pretty strongly. So as you get into religious expression, you're going to want to look at, well, when is that expression occurring? Are they reading their religious book, whatever that is, whether it's Bible, the Torah, or some other religious book? Are they doing that during a time when they could, maybe it's a free hour they have, and you would otherwise allow your employees to read books during that time? Maybe they might read a fiction novel or something. If you would allow them to do that and they're not actively supervising, they're not actively instructing, then they would certainly also be able to read that religious book. Likewise, at those times, they'd be able to pray. If this is not a time where they're actively instructing, actively coaching, actively leading the band, the choir, whatever the activity might be, that they certainly have the ability to pray at those times. Now, having said that, while it was not part of the court's holding in Kennedy, they did still note, or they made some reference anyway to the captive audience of the students as well. So that's something, again, and that goes back to when that expression is being done. Okay. And so if you had, for instance, a time where you had, let's just say, I'll give you an example, a teacher, and they give students some free time and they're in the back of the room and they start, maybe they say, oh, I'm still supervising the kids, but they start openly praying and they're doing this out loud. And the students are hearing this. They don't have any choice but to hear it. Well, that would be an example of a captive audience of those students. So while it was not a holding there, I would anticipate, my educated guess would be that the Supreme Court would say, well, no, at that time, in that manner, those students were still a captive audience. They should be able to study and do that work in the classroom without sitting there and hearing the teacher go through their personal prayer, whatever their beliefs are again, and not be required to listen to that at that time. So anyway, so that's a little bit more on the religious expression. I guess I should throw in also that we have times where questions come, well, what about religious symbols? Yes, teachers may wear some religious symbols, but I go back to the captive audience. There's a big difference between a teacher wearing a let's say some type of jewelry, a necklace, and earrings or something like that that have some small religious symbols on them, whatever those are, as opposed to an individual coming into the classroom and they have a great big, you can imagine, like you see some of our musicians wearing great big jewelry, but you can't help it's drawing all your attention to that. And again, back to the captive audience, I think there could be some real questions raised in those instances where you're looking at, well, what are really cultural norms here as far as religious expression and what is used for that religious expression? And is this something that should, there may be a concern? So, anyway, hopefully I answered a lot of the questions you had. Again, I know this has been a very difficult time in our schools and in our country as well. Hopefully, I've helped to bring a little bit of clarity to you on this. But again, remember that your school board makes hiring and firing decisions. And I know you realize that, but when we have public employees celebrating violence, when we have public employees encouraging the illegal use of drugs or other things like that, you say, you know what? No, we're drawing a hard line here. We're recommending termination and leave it to your board. And then hopefully your board then we trust is being held accountable by voters in your community to make the decision they need to make. And then beyond that, of course, we have the Board of Educational Examiners. We could get them involved. You could get them involved, I should say, and they could make determinations of whether or not this is an individual that should be in our classrooms or should be a leader in our buildings or our school districts. So thanks so much. I hope you've enjoyed this first episode of Legal Vortex. You know how to reach me, so send me an email, mcarver@sai-iowa.org, or I love to get calls as well from our members, 515-267-1115. Until next time, I appreciate all of you and what you do to educate the kids in our great state. Thanks so much.